Yeah, let's sit that one in the shade. You're squinting.
All right. Hey, guys, it's Bernard Nomberg, Nomberg Law Firm from Birmingham, Alabama. We've got David, of course, and we've got our friend Ben Gerber, who's going to come into the frame with us. Ben is with Holder and Gerber out of the Atlanta area. Hey, guys, how are y'all doing? Obviously, we're not in our office today. We're in a great setting. We're out in Santa Barbara, California for a national work comp seminar. We've got so many great things to share with you guys. We hope you'll be able to spend some time with us today. What do you think of the place where we are so far, guys?
Beats the conference room in Birmingham by a little bit.
Just a little bit. Just a little bit.
30 degrees warmer than Atlanta right now.
Mm-hmm. Well, we're obviously outside. We're on a patio. You can see the ocean behind us. We're probably have a lot of background noise, so just try to work through it with us, guys. And we hope you'll spend about 20-30 minutes with us. We've got so many great things to talk to you about. And as we're trying to do with this new show, every the third or fourth Thursday of every month, we're going to come to you with Alabama Work Comp Today. We're going to talk about some things that are in the national news. We're going to talk about things that are related closer to home in Alabama. And we've got Ben from Georgia, and we're going to do a little contrasting with Georgia law. So we hope that if you've got any questions or comments, just throw them over there and we'll field them. So thank you for spending some time with us today. Let's see. We are at, like I said, it's the WILIG. Workers, help me guys, I'm new to the organization.
Workers Injury Law and Advocacy Group. It's a nationwide organization made up of claimants lawyers or plaintiffs lawyers who represent injured workers. And all 50 states are represented, got about 1,000 members in the group, and our conference will start on Sunday with a board meeting. Ben's been a member for several years, as have I. We're serving on the board of directors. It's a great organization, and it's always a fun conference.
And David will be speaking later this week at the conference. We're looking forward to hearing him on that. All right, guys, let's talk about some national news. And one of the things that I want to talk about is the new law. We're in California. I think it's appropriate for us to bring this up. Governor Newsom signed several new laws in the last several weeks, but we're going to talk about the California Fair Pay to Play Act. And in general, or most people think it of, is it's now a way for college athletes to make money off of their likeness, off of who they are. And I know you guys have been doing some reading. Ben, you got any initial thoughts about that?
I think it's fantastic law. It's not going to really affect workers' compensation that much. They're very specific in the actual statute that says it does not affect workers' compensation. But it's going to allow players to receive money for their likeness. And quite frankly, my kids are very excited because it means NCAA football will be back on the PlayStation, Xbox, and all that.
That's right. That's good stuff. David, what's your thoughts?
And what's interesting, what you said, Ben, is that in California, again, this is the first law that was passed in California, the first state to pass the law, but it doesn't go into effect for about 4 years. So that if you're a college-age athlete right now, you probably won't benefit from this. But in fact, your kids, if they make it to college and on scholarship, so what they're saying is that it's potentially the junior or middle schoolers and high schoolers now that may benefit from this law. If it is in effect in 2023, I think is when it.
Yeah, it's a shot across the bow. It's telling the NCAA, you guys need to modernize your laws. And for so many years, part of the argument has been, well, the athletes get scholarships. They have their books and room and board and all of that paid for. Shouldn't that be enough? Well, clearly it's showing that the universities, the coaches, everybody else profits and makes off handsomely, except for the people who are performing on the sports fields. And I think that this law will hopefully now get more attention because several states, 6 or 7 or 8 other states, have now proposed in their own states' legislatures potential new laws like this. So maybe the momentum is going, and hopefully the NCAA will be proactive and find something that helps out all these athletes.
We actually have some legislators in Georgia who have come out and said they will never pass a law like this, and they're going to try to submit legislation that will prevent Georgia from playing any school in any state that has this law.
Wow.
And interestingly, your neighbor state, South Carolina, there's going to be proposed legislation out of South Carolina modeled after this California legislation. So it'll be very, very interesting to see if this comes into the South and you got one state in support of it versus Georgia, which may not be in support of it.
California, I think, has either the fifth or sixth gross national economy in the world. And I don't see how schools are going to stop playing schools from California, et cetera. So this is going to be an ongoing topic and conversation for many, many months coming up. Hopefully, some of the people at the NCAA are taking this seriously enough that they'll make some real changes that won't affect what's going on the field as well as what's going on off the field. Any final or other thoughts, you guys, about what you foresee coming up with this?
Well, one note I made was this is potentially a new practice area for lawyers. We've seen a lot of new practice areas over the year develop from like artificial intelligence and cannabis, and now you've got another potential practice area for lawyers. So keep an eye on.
I wonder, Ben, if this is going to classify the athletes as employees at some point.
And that's where we're headed eventually. I don't know if this legislation will, but eventually we'll get legislation where the student athletes get compensated for their services and they're classified as employees.
Yeah, at least in Alabama, one of the tenements of the work comp law is for you have to be an employee receiving compensation for the work you do. And if you get hurt on the job, then you potentially could be eligible. But if you're not getting compensation, like a work release, a prisoner who doesn't get compensated, they don't have those same rights.
Well, on that note, the state of New York is considering similar legislation to what California has proposed. And they would also include a requirement that colleges establish a fund for injured athletes that will pay athletes who have suffered career-ending or long-term injuries, which is kind of very similar to a work comp system.
And guys, I'm sorry that we're so much in the shadows. You really can't see us as well as you can see out there, but we hope you're at least getting the gist of and hearing what we're having to say. So thank you for sticking with us for a little bit.
It's probably better they don't see our faces.
That's right. That's right. Maybe I can only do so much, guys, with the screen.
Yeah, beyond us, it's beautiful.
All right, guys, let's move on. This is not exactly new news. This has been in the last 6 months or so, where Amazon has hired or is in the process of hiring 3,000 work-from-home employees with full benefits. And how does this? We've talked previously. David and I talked about the gig economy. That's people who work for delivery services like Lyft or Uber, etc. Anybody who has a job that is, you control your own hours, but you don't have the same benefits as protections as an employee. And we don't have to go fully into what the gig economy is, but I'm interested to see how this is going to play out for Amazon hiring these work from home employees. Any thoughts on that, Dave?
As a avid and frequent Amazon shopper,
That's right.
I'm all in favor of this. As I understand, these positions are going to be more customer service based, answering questions, and so it makes sense that they need employees who can work from anywhere essentially, but also have hours that they can work 24/7. I think it's great they're offering them full benefits, which would include workers' compensation benefits, because I'm all in favor of employees having benefits such as work comp. It will be interesting if they do injure themselves at home, how that's documented and what the process is for them to be covered by that. But that's another story. But anyway, this is a wonderful thing that they're covered.
I think that is the story, though. I mean, there's going to be so much litigation on every single injury. Think about it. How do you report this injury? You have to report it a certain amount of time. How'd you get hurt? And you didn't properly secure your refrigerator and it falls on top of you? I mean, it's a horrible scenario, but think about that. I mean,
it does raise a lot of interesting questions and issues going forward for people that work at home.
Oh, absolutely. But let me give you an example. Let's say you're working at home and you're on the phone for Amazon doing customer service, and you're getting up to walk yourself a glass of water while you're still talking. And your dog runs across your feet and you trip and fall and severely hurt yourself. I mean, seriously, is that going to be a workers' compensation case or not?
Yeah. Yep. And there's so many jobs out there. In addition to this Amazon new hiring phase, there's so many work at home or telecommuter jobs that are already out there. And every state treats it a little bit differently. I know in Alabama, they're very difficult cases to prove. They're very difficult to show how you were still in the line and the scope of your job, even though you were in your makeshift office and you're walking into your kitchen like you're mentioning, those cases are just, they're litigated because they're so disputed.
To your point, Ben, one of the requirements for this job is to have a distraction-free workspace. So,
How do you do that at home?
I mean, have fun litigating that.
Yeah. Well, guys, again, all of these topics, we could spend the whole session talking about this. We're just trying to hit some of the high points. We're going to keep moving through some of our national discussions or topics. And then the next one I want to go to, there was some news this past week about Liberty Mutual, one of the big insurance companies in our country, and they're accused of inflating comp premiums. And that may not mean a lot to the average person who reads that as a headline or a byline in newspaper or online. But for folks who do what we do, work comp and representing the injured workers, this is pretty big. This is going to be a big piece of news in our world for quite a while. And Ben, what have you found out from your readings?
Yeah, so in Georgia, we don't have subrogation like you do in many other states. So it didn't really apply to Georgia. We got lucky with that. Liberty Mutual still writes policies in Georgia. That hasn't changed at all. But I imagine that they're going to have a significant slowdown in the policies they can write because they're going to be fighting this litigation among, according to the article, numerous states, Florida, Alabama. It's going to be very, very difficult for them.
Yeah, and I'm not sure how many states they write insurance in, but it's probably more than half of the country.
I think so.
I'm going to give a quick summary about this case. So here's what the lawsuit alleges. An employee of a company called Valley Container Company, an employee got hurt at work, and the Liberty Mutual recovered about $47,000 in subrogation from the third party that caused injury to the employee. They recovered about all the money except about $120. And what the lawsuit alleges is that as a result, that company's premiums were artificially inflated. Liberty Mutual failed to reimburse the company for the excess premium. Now, what's interesting about this was filed in the U.S. District Court up in Boston, and they allege breach of contract, unjust enrichment, and violations of the Racketeer Influence and Corrupt Organizations Act, which is, you may have heard, RICO, which is what the federal government uses to process crime families such as mafia families. So, very interesting lawsuit.
Well, it's not one that's going to go away anytime soon. Much like all these other national different news pieces, this is going to go on for quite a while. And whether the downstream effect gets to the injured workers or affects employers, how much they're paying, that remains to be seen. But I know on both sides of the fence, they're watching this case and this news unfold quite a bit. All right, guys, let's transition. We're going to go out of national news. Let's talk about, as we did last time, David, we brought up one of our prior cases. And these cases that we bring up are Alabama cases that David or I have handled in the firm in the last 15 years. And we're not necessarily talking about big money or large settlements. That's not really what we're bringing this to you about. We're trying to find a nuance in the law. We want to show you how Alabama law works. And we've got Ben here, who's in Georgia, works out of Georgia, and we're gonna compare with what Alabama's limitations and how one of our cases with one of what would happen if the same case happened in Georgia. So, Dave, why don't you share one of your cases that we've talked about?
Sure. So this case is from many years ago. I think it's one of my first trials. In fact, my client injured himself at work, had an eye injury, lost vision in his eye. And we ended up trying the case and had a very good result. We had the best result we could have under Alabama work comp law at that time.
What year was this?
This is probably about 2005, 2006.
Okay, it's more than 10 years ago, but it's still under our current act and laws that were passed in '92.
That's right. So the judge ruled for our client and found that he had 100% loss of vision to his eye. And
Just one eye.
Just one eye.
Okay.
He was awarded medical benefits as well. And the total recovery for our client, based on 100% loss of vision to that one eye, was a little over $27,000. And that was more than 10 years ago. And today, the case, if I tried that same case today, the case would still be valued at a little over $27,000.
So if this was in 1993, still worth $27,000. And as you know, as we all know, the cost of living has greatly increased over the years. The average cost of everything in milk, gas, medical bills, everything has gone up, but not the value or the worth of the loss of an eye in Alabama. Ben, compare that to what you deal with in Georgia.
Yeah, we're significantly different. The legislature in Georgia passes laws pretty often increasing the average weekly wage, and our permanent partial disability rating is actually tied to the average weekly wage of the individual, and the only cap they have is the general cap on temporary total disability benefits. I know you guys have a separate cap for permanent partial disability ratings. We don't have that in Georgia. So that same case in Georgia that's worth $27,000, let's just say back in 2004, if it's just for the loss of an eye, it would be worth almost 3 times that. And nowadays it could be worth, $675 per week for up to 150 weeks for the loss of an eye. So,
what a big contrast to neighboring
contrast.
states. And it's just, and this is not to get on our soapbox, but we do this every week, complain about this. But hopefully one day we're going to modernize the Alabama laws. But for now, we're stuck at $27,000 for an eye, as opposed to many, many more times in one of our border states.
Let me ask you a question real quick. Can you get psychological treatment under the workers' comp statute in Alabama?
If there's physical injury as well.
Okay, we have the same issue there in Georgia.
Well, they recently in Florida, I know, they recently passed legislation that changes it so firefighters, for example, or first responders, they don't have to show a physical injury anymore. Paolo Longo has been teaching us and telling us about that, our buddy out of Orlando.
It's called a mental injury as opposed to physical mental.
Guys, in any of these topics that we're talking about, whether you're watching us live or later on, if you've got any comments, questions, concerns, just send it in the comments or shoot us an email or phone, however you want to get in touch with us. We always appreciate folks who show interest and want to talk about the law and even commiserate about how crappy your case may be. All right, guys, let's talk in general on this same thing, comparing Alabama versus Georgia law, and we're getting close to the end of our discussion for today. So thank you for hanging in there with us. We always try to look, Ben, if we have a case that's called a scheduled member injury case, we always try to get outside the schedule and make it a body as a whole.
Okay.
And I'm going to let David just give us a quick comparison of what the two types of cases are, and then we'll come to you.
Okay. So in Alabama, we have certain body parts that are called in the schedule, and those are fingers, their toes, the hand, arm, leg, hearing, eyesight, as I mentioned before. Those are what's called scheduled injuries, and I'll explain what that means in a little bit. Then we have what's called the body as a whole. Body as a whole injuries are neck, back, hips, shoulders, or a head injury. And so you've got two different ways to value cases, and the schedule says that certain body parts are worth certain amounts of money. So in other words, an arm may be worth 200 weeks. It benefits $220 per week is the maximum you can get.
$44,000 or $48,000 if you completely lose your arm.
Your hand's worth about $37,000. Your vision in one eye, as we mentioned, is worth about $27,000.
Stop shaking your head, Ben.
Yeah, it's
and those
egregious.
And in those those laws have been in place in Alabama since the late 80s. They have not changed. They've not gone up with inflation. And so that's the schedule versus body as a whole.
And this is why we try to get outside the schedule, because when you get outside the schedule and get those body as a whole injuries, your potential benefits are much greater. There's many more weeks that can be added on, and it eventually makes, or could ultimately make, the value of the case much more valuable than a scheduled member. So Ben, talk to us. What's an arm worth?
So these are great questions. Arm is worth 225,000.
Yeah.
Sorry, excuse me, 225 weeks in the state of Georgia, and it's based upon your workers' compensation rate. So
Right.
once again, we're not capped at. You guys are capped at
$220.
Yeah, I mean, we're capped at $675 if the injury took place after July 1st.
So three times.
So literally 3 times.
Yeah.
Plus more weeks for each body part.
Yeah.
You said the arm was 220.
200 to 220 weeks.
Yeah.
We're we're higher than that. for most body
Look at
parts.
this example, Ben. Let's say we've got somebody living in Heflin, Alabama, right on the Alabama-Georgia line, maybe 10 minutes or 10 miles to the Georgia line. He and his buddy, who are neighbors, but one works in Georgia and the other works in Alabama, and they have the same injury. A little bit different how
Yeah.
much their cases are worth, and
So
that's the stark reality.
Let me give you another example. And I actually called David about this case a few months ago. My client lived in Columbus, worked in Phoenix City, got hurt in Phoenix City, but the employer was in Georgia. So we fought and we got jurisdiction in Georgia as opposed to Alabama because the benefits are significantly better for the injured worker in the state of Georgia.
Well, guys, we could sit here and talk all day and disrupt what's going on around the poolside, but I think we're going to come to the end of our discussion for now. We do have a blog that's going to be coming out that's going to touch on this last part. What we were talking about is why you can't retire off of your workers' compensation case. We go into a little more detail, explaining and contrasting about how Alabama laws are just pretty much antiquated and outdated for now. But Ben, we want to thank you for spending your time with us at this seminar and this conference we're about to go to. And thank you for your expertise and your knowledge.
Thank you very much for inviting me on the show.
And David, any closing words? Anything you want to share?
Just look beyond us, how awesome that
That's
is.
right. That's right.
We're excited about being here and learning a little bit more about work comp from our friends all across the country. And thanks again to Ben Gerber at Gerber Holder in Atlanta for joining us today.
Thank you, guys. And that'll end it for now. We hope you guys are doing well, and we'll catch you this time next month. Be well.